My name is Douglas Elliott. I'm a partner in the law firm of Roy Elliott O'Connor in Toronto, and I have been a very active Charter of Rights lawyer. Like a number of people in the community, in the early 80s, I wasn't really that involved in the Section 15 cases because I was busy dealing with the AIDS epidemic. I was very involved in the AIDS Committee of Toronto and other issues. Over time, it became apparent that Section 15 was working for us, and I really wanted to get involved in Section 15 cases because I was a gay man, because I was concerned about the LGBT community, because I saw that it was a tool that would work for us. The first case that I was involved in was the Thwaites case that involved a sailor that was HIV positive and was going to be thrown out of the Navy because he was HIV positive after it had been ruled that they couldn't throw him out for being gay, and that case was successful. I also got involved in the Vreend case, the Vreend in Alberta case, one of the most important early cases. And I got involved in that in two unusual ways. It came about because of the Creever inquiry. I was in Alberta when the Vreend decision came down, and Delwyn Vreend was working for the AIDS Network of Edmonton Society at the time, and the only lawyer he could find who would represent him in Alberta in connection with that case had moved out of the province, and so he had no lawyer. And using slightly dishonest means, I was able to get a meeting with Sheila Grekel, who I had heard was a fantastic lawyer, and she thought I was there to interview her about the Creever inquiry, and I admitted I was really there to recruit her to represent Delwyn Vreend. And after some discussion, she agreed to take on the case, and eventually she ended up taking the case to the Supreme Court of Canada after a horrible ruling from the Alberta Court of Appeal, where one of the judges compared gays and lesbians to serial killers like Jeffrey Dahmer and Clifford Olson, one of the most despicable rulings we've ever had. But we appeared together because the Canadian AIDS Society, who I was representing at the Creever inquiry into the blood system, agreed to intervene in that case in support of Delwyn Vreend, as they did in a number of cases. And they were supporting Delwyn Vreend because we understood very well from cases like Thwaites that if you could discriminate against a gay man with HIV, if he was protected on physical disability, then you discriminate against him because he's gay, or vice versa. So you really needed protection from both forms of discrimination. That was an interesting one as well. I remember very well that Justice McLaughlin was not the Chief Justice then. She's originally from Alberta, from Pincher Creek. And when I had made my argument, the lawyer for Alberta, in responding to the argument, said, "I don't understand Mr. Elliott's concern. People with HIV are protected from discrimination based on their physical disability. They don't need sexual orientation." And Justice McLaughlin said, "Do I understand it to be the position of the government of Alberta that the solution to the problem of discrimination of gay men in Alberta is that they should all get AIDS?" There was a kind of nervous laugh in the courtroom, but I think the lawyer representing the government of Alberta wished that the earth could open up and swallow him. I knew we were going to win the case after that comment. I was involved in the Mark Hall case, where a young man wanted to take his same-sex date to a Catholic school prom. That was a very challenging case, but ultimately successful, and Mark was allowed to take his date to the prom at his Catholic school. And lo and behold, nothing bad happened. I was involved in the Little Sisters bookstore case, where it was found that the Customs Department had been deliberately targeting a lesbian and gay bookstore, had been harassing them almost out of business. And the Supreme Court of Canada found that as a fact and issued an order against the Government of Canada. Not as strong as the one I would have liked, but they issued an order against the Government of Canada in connection with that case. I've been involved in also the M versus H case, another very important case. That case was, we were looking to advance the Vasey case further. We had taken our time. We really felt we needed the Vreen decision there to have the basic anti-discrimination protection. And also to get the Supreme Court of Canada comfortable with the idea that they could order the government to do something. In that Vreen case, they actually inserted sexual orientation into the Alberta human rights legislation. They didn't wait for the Alberta government to respond. Now, of course, the Alberta government could have used the notwithstanding clause, but the Supreme Court of Canada kind of threw down the gauntlet first. In the M versus H case, that was about same-sex couples. That was considered a little more difficult than individuals, as in the Vreen case. It dealt with a situation where M had been thrown out into the street by her partner with very little money. I think she had less than $10 to her name at that point, and she had sought spousal support from her partner. She couldn't get it under the Family Law Act of Ontario at the time because it was restricted to opposite-sex couples, but including common-law couples. We thought it was an ideal case to advance a same-sex couples claim because, unlike the Egan case, which had been earlier argued, and Egan was an important case, don't get me wrong. Egan had said that sexual orientation was included and that same-sex couples were, in theory, entitled to protection from discrimination, but it had failed because of Section 1. And one of the reasons it had failed is because it was going to cost the government money, because it involved old age pensions that came out of taxes. In M versus H, in contrast, we were dealing with a case where the person was seeking money from their same-sex partner. And as I pointed out, if they couldn't get money from their partner, they might have to go to welfare, and they might fall back on the public purse. So in fact, the government was subsidizing the discrimination. They were paying a premium for discrimination. They weren't saving money. So we thought it was a very compelling case. And indeed, the overwhelming majority of the Supreme Court of Canada agreed with us, said that same-sex couples were entitled to the protection of the Family Law Act, that the law needed to be amended, and it went further and said that gays and lesbians should not have to wait any longer to have laws changed, that all of these laws needed to be reformed, but without commenting on marriage. And the marriage fight was left for another day.